Mr. Ali, have you had time prior to today to talk to Mr. Kading about whether or not you will testify during the trial?
Yes.
And did you have time to talk with him today again about whether or not you would testify during the trial?
No. Yes.
Oh, thank you. Do you understand that you have an absolute right to remain silent and not testify?
Yes.
And do you understand that you also have an absolute right to take the stand and testify on your own behalf?
Yes.
Mr. Kading has indicated that you are choosing not to testify. Is that true?
Can you repeat the question?
Mr. Kading has indicated that you are choosing not to testify during the trial. Is that true?
No. No. No.
Okay. Can you give me the smile?
That's not true.
Okay, now we can hear. I'll repeat the question.
Okay.
Say again. لا أريد أن أدخل في application هذا الفكرة هذه المحاكمة هذا صحيح؟
لا I don't understand the question correctly.
So,
I can do the consecutive in this case.
Okay.
يعني شنو بالضبط هو ما جبرني اني اسوي شيء انا من ذاتي ما اريد احط شغلات.
Yeah, I don't want to take the stand, and he did not force me to take this decision.
Okay. And so, Mr. Kading told me on your behalf that you are not going to testify.
No. That's correct.
Okay. And so that's a true statement that Mr. Kading gave me, that you are choosing not to testify.
Yes.
Mrs. Ali, prior to today, have you had a chance to speak with Mr. Leary about whether you would testify during this trial?
Yes.
And today, have you had an opportunity to talk with Mr. Leary again about whether or not you will testify during the trial?
Yes.
Do you understand that you have an absolute right to remain silent?
Yes.
And that you also have an absolute right to take the stand and testify on your own behalf?
Yes.
Mr. Leary has indicated that you are choosing to not testify during the trial. Is what he said true?
Yes.
Has anyone promised you anything to get you to not testify?
No.
Is anyone forcing you to not testify?
No.
Okay, so we will not hear from the defendants on the stand. I want to hear some thoughts from our guest legal analyst. She is a magistrate judge, also high-profile criminal defense attorney and former prosecutor, Kimberly Bando, on the show today. So, Kimberly, just some general thoughts from you. As we were talking off camera a little bit, I really appreciated your comments about the daughter. Tell me what you think as you're looking in on the facts of this case and what transpired prior to the incident at the bus stop.
I think because culturally, she's probably not allowed to have a boyfriend at her age. And I think that's this whole backdrop about the shame culture and her not being with a boy and potentially what would happen. And I think that's probably what precipitated all of this. Obviously, it's the boyfriend. And so I was just saying that when we were reading the notes that they had on the screen, that they were leaving for Iraq. even if you haven't been to Iraq, she probably knows more than anybody what the culture is there. And that's probably why that was like the day that she had to make a decision, because she knew nothing good was going to come to her if she left U.S. soil and returned to Iraq with her family. Because look what they did here in the United States in broad daylight, and they know that it's against the law. And they did it because they were determined to get it done.
I love your analysis, Judge. That video, it is so chilling. And we were able to slow it down. Our editors were able to kind of put markers there so you can see where Dad is, where boyfriend Isaiah is, where Fatima is. And Dad is relentless. Take a look at this. This is slowed down. So we see Dad, his daughter, and the boyfriend on the side. They're trying to jump in and help. He's got the Nike bag there. And look, I mean, Dad clocks him. And he just will not relent. And this is all to stop her from, getting on the bus. I mean, can you imagine? I keep thinking about if this happened, like you said, publicly, broad daylight at a bus stop. I would love to know what goes on in that household, wouldn't you, Judge?
Oh, yeah. I'm sure that child has experienced so much violence, mental abuse, physical abuse, emotional abuse in every aspect of her life, that she just finally just made a run for it, literally made a run for it to leave it alone, because she knew that this was not going to end well for her and probably end her life.
Right. You're so right. Thank God she's thriving. She's in the care of the state. And she just turned 18, so now it'll be interesting to see what will happen. But our last check, she's in state care, and so we'll see going forward what occurs. Judge Bando, stand by for more cues, please. I'm Bando. We're going to hit a break. When we come back, we got more unaired footage from the attempted honor killing trial. The video, unbelievable. This is the attempted honor killing trial, and we're getting ready for the charge conference to happen today. Closing arguments will happen on Monday. And we're airing some footage we have yet to air for you because of everything going on yesterday with the sentencing in Idaho. We were unable to take you to this case in Washington and show you all that happened. So we just got through the portion where the defendants both acknowledged to the court that they will not be testifying. So everybody rested, and at one point, after the state rests, there's a standard motion that defense counsel will always make, a motion for a directed verdict or judgment of acquittal, depending on what jurisdiction you're in. So here was a motion for directed verdict. Let's take a listen to the arguments defense counsel made, the state's response, and then the judge's ruling.
I had to wait for them to rest officially. At this time, Your Honor, I'd move in Mr. Ali's case to dismiss count 3, which is an unlawful imprisonment. The allegation against him is that he somehow restrained his daughter unlawfully, apparently. She was at the time a minor. He was her parent. There does not appear to be a basis in law for the count of unlawful imprisonment. And for that reason, I would ask the case to be dismissed at this time. Similarly, on the assault in the first degree, the requirement is that there has to be an intent to commit a serious bodily injury. And in this case, excuse my language, I was looking for a charging document, but if I could have just 1 second on that. Looking at I thought I had it, but it was actually not it. The language on the charging document for the assault first degree. Yeah, absolutely. I got this one. I apologize. This was the one that was handed to me morning, first day.
I can read it. I have it in front of me.
You have it in front of you, Your Honor.
Count 2 says, on or about October 18, 2024, as principal or as an accomplice, did assault another person, FIA, that the assault was committed by a force or means likely to inflict great bodily harm or death, and that the defendant acted with intent to inflict great bodily harm.
Right, and in this case, great bodily harm or death, the intent to inflict that has not been shown by the evidence that we have here. What we had was a strangulation case, which is defined obviously differently. And so if the state's language is to be taken in general, any strangulation case would become a assault 1, and clearly it's not. There's a specific assault 2 charge here that they did not charge with strangulation, and they didn't show any other intent to do anything other than strangle. No intent to cause bodily injury that would permanently affect any bodily function or disfigure or otherwise. So for that reason, I move to dismiss count 2 as well.
Thank you. Ms. Stone, are you going to address these arguments?
I am, Your Honor.
All right.
First of all, you don't get to restrain your child, anyone, let alone whether they're your child or they're an adult, by choking them into unconsciousness. You just don't. You don't get to restrain a person for that purpose. So that is an inaccurate statement that just because he's her dad, he gets to restrain her as a minor in whatever way he wants and for whatever purpose. So in terms of the unlawful imprisonment, the facts have been established and the testimony has been provided for a prima facie case for that, to defeat that argument. As it relates to assault in the first degree, again, a prima facie case has been established for that. I don't have the case directly on hand. Certainly I wasn't aware, and counsel doesn't have to tell me, but there is a case directly on point that says you can, in fact, commit assault in the first degree by strangling someone. Assault is, strangulation is not merely an assault to conviction, which appears to be the argument that counsel is making. In fact, in the case that I'm thinking of, and like I said, I'll need a minute to go back and find it for the court. But the case that I'm thinking of, that is exactly the argument that defense made in that case, that it couldn't be an assault 1 because there is a strangulation prong specific for assault 2. And the reviewing court said that's not the case. It can also be an assault 2 by strangulation, but certainly strangulation can rise to the level of assault 1, whether it is completed or it is done with the force intended for great bodily harm. That the state doesn't even need to prove the great bodily harm occurred, simply that that was the intent and the force used was done for that purpose. So the prima facie case for assault in the first degree absolutely has been demonstrated for this jury, and that is a question of fact for the jury to decide. I would ask the court to deny those motions.
All right. I want to get something out of my chambers. And so this will be a good time to do that so that also Ms. Stone, so that the record can be complete and I can look at what you are referring to. I will take, do you need more than 5 minutes? I don't need more than 5 minutes to get what I need out of my chambers.
Your Honor, my Lexus is still loading.
Okay, so as soon as you have the case and are able to also provide that site to counsel, let my clerk know and she'll call me and I will come in.
Yes, Your Honor, thank you.
Thank you.
All rise. Court's in recess.
Okay, we're going to hear more from the judge in just a moment. She's taking her break. We'll take ours. We'll be right back with more unaired footage from this case in Washington.
Matriarch of the Adelson family gets arrested.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot. Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins this August on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. Let's take you into the courtroom now. We're going to hear more from the judge, her response to the defense's motion for directed verdict.
All right, the first issue raised by Mr. Kading was a request to dismiss the count 3 unlawful imprisonment, indicating an insufficiency of evidence as to the restriction of Fatima's movements, indicating that the evidence shows that Mr. Ali is her father and that he has the right to restrain her. So first of all, there's been a significant amount of evidence that has been introduced in this case. And interestingly enough, I have thought about this issue in the course of the trial, just as I've thought about the evidence and the facts in this case. I was specifically thinking about this issue when I was working on the jury instructions. One of the jury instructions proposed by Mr. Kading on Mr. Ali's behalf is the affirmative defense of that the force was lawful as it relates to the allegation of assault, as it defined in the instruction related to discipline of a child. That instruction, of course, applies or could apply to the assault charge, which is count 2. And that instruction says in part, you may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing any act that is likely to cause and that does cause bodily harm greater than transient pain. The reason I was thinking of this in conjunction with the unlawful imprisonment is because it says it's unreasonable to do one of these acts to correct or restrain a child. And the evidence that the state is relying upon relates to an unlawful restraint from their opinion, which includes the argument that Ms. Stone made as it relates to strangling Fatima until she went unconscious. Clearly, parents do have the right to reasonably restrain their children. We ground our kids all the time, can't leave the house and do all of those things, but certainly the evidence presented in this case is sufficient to go to a jury, and I don't find that parents have an unchecked ability to restrain their children, or that the law allows for that. And therefore, I will deny the motion to dismiss the unlawful imprisonment charge. Certainly, Mr. Kading has the ability to make all of those arguments, in fact, to the jury as it relates to their consideration of the case. As it relates for the request to dismiss the assault in the first degree, Ms. Stone has provided 2 cases. Mr. Kading, did you have a chance to look at those?
Your Honor, I did have a chance to look at Osman, and I think Osman predated the amendment to the assault charge. I also believe that that case involved a lot more of it involved a ligature, a sock in the mouth, and other intentional acts that would seem to elevate it beyond a simple strangulation.
And I understand that Mr. Kading just got it, but it may be helpful if he looks at paragraph 37, which makes that analysis in Osman separate and apart from the 3 means in which they decided that that was not an appropriate argument or a lawful argument on behalf of, maybe persuasive is the better word, on behalf of defense. Paragraph 37, standing alone, which is at, I believe, star 19 in the copy that the state has. It's page 6 of 6. addresses that specifically in terms of the amendment, saying it plainly it doesn't matter by the plain language of the new statute, which is the current one under which we operate. So those facts are irrelevant to the analysis. They, in this case, were yet another reason, but the statute standing alone is sufficient.
And again, Your Honor, I would just say that it's clear in Osman that the intent was entirely different. That involved someone who was putting a gag in the mouth, putting chains around somebody's throat, tightening it, loosening it, tightening it, loosening it over a period of time, which is clearly nothing like what was the intent in this case.
All right, thank you.
The only other thing, I apologize, Your Honor, I would note is that the court also in Osman at paragraph 11 specifically says it addressed the asphyxiation piece, and then also separately in terms of the sufficiency of the evidence argument, specifically addressed that the presence of the petechiae on the neck also permitted the jury to find that the strangulation was likely to produce at least great bodily harm. The evidence supported the verdict on count 1. So it addressed the strangulation separately and apart as well, and consistent with that.
All right, thank you. So I read both of the cases, and although I would not have been able to quickly find these cases, I am familiar with this body of law in general, as it relates to the fact that strangulation does not have to solely be charged under the Assault 2 statute, as I believe that both of these cases address clearly under the evidence that has been presented at trial. The state has presented prima facie evidence of assault in the first degree related to the fact that the facts are that Mr. Ali had Fatima in a I'm going to use the term chokehold, but that his arm was wrapped around her neck, and that he was squeezing her neck to the point that she became unconscious. She had multiple injuries on her neck. She had the petechiae. Dr. Gilbert testified at length regarding the injuries and the potential impact of what Fatima experienced, and therefore I find that clearly the law allows for it, and that there has been prima facie evidence presented by the state that allows assault in the first degree to be something that will go to the jury for their consideration. Have any other motions, Mr. Cady?
No, Your Honor, thank you.
So I don't want to just bring the jury back in if I'm going to have Mr. Leary indicate that he has something for my consideration.
Not today, Your Honor.
All right. Bring the jury back in, please. Mr. Kading?
Thank you, Your Honor. At this time, the defense for Mr. Ali will rest.
Thank you. Mr. Leary?
You have a Zahraa Ali defense rest. Thank you.
Thank you. Members of the jury, the evidence is now closed on Monday at 9 a.m. We will begin the closing arguments. Closing arguments will conclude by the end of the day on Monday, and then you will begin your deliberations. We're going to order lunch for you on Monday, and what that means for you also is that you'll hear a portion of the closing arguments, then we're going to take a break and be able to have lunch, not our normal hour-and-a-half break, and then we'll resume the closing arguments. All right. So that means that you are going to have Thursday, Friday, Saturday, Sunday. You're going to have 4 days, and it continues to be so vitally important that you ensure that in those 4 days, I know you have all been very careful and vigilant, but that you continue to be careful and vigilant to ensure that you are not exposed to any outside information about this case or about the law that applies to this case.